Hello, my name is Adam Kielich. I'm the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help people with employment law, family law, and personal injury needs. Today's video is going to discuss a type of wrongful termination or wrongful discharge claim called a Sabine pilot claim. We'll talk a little bit about the framework of how we get to what is a Sabine pilot claim. Of course, we're going to talk about what a Sabine pilot claim is, and we'll talk as well about some of the mechanics of how these claims work. So to start off, let's talk a little bit about what wrongful termination or wrongful discharge really means. For the most part in Texas, a wrongful termination claim exists because a particular statute has said it's unlawful to fire an employee for X reason. And that X reason is something that's spelled out within a statute. That might be a prohibition on firing somebody because of a particular kind of discrimination, like their race, their sex, a disability, their religion, so forth, age, so forth. That reason that's prohibited by statute might be because the employee complained about discrimination or complained about not being paid their wages or complained about a safety condition at work. These would be reasons why an employee could bring a wrongful termination claim. An employee might also bring a wrongful termination claim if the employee works under a contract and the employer has fired the employee in violation of that contract. These are often brought just as breach of contract claims, but it is a wrongful termination to fire somebody in violation of a contract between the parties. Outside of specific statutory or contractual reasons, any other kind of termination might be wrongful in a general sense, but from a legal sense, it's not wrongful. Just because a termination is unfair or puts the employee at a disadvantage, or maybe is even based upon a fraudulent or made-up reason, does not make it wrongful by law. Under Texas law, there's only one exception that allows somebody to bring a wrongful termination claim that is not based upon a statutory right or a contractual provision. And that is a Sabine pilot claim. So let's talk about what a Sabine pilot claim is. This is a claim that's brought by somebody who has been terminated for refusing to perform an illegal act on behalf of the employer, where the employee is terminated specifically because the employer said, do this act or you're fired. This came about under a case that was filed against Sabine Pilot. They were the employer, where the employee was asked to commit a criminal act, and when the employee refused, the employee was fired. Right? That's exactly what a Sabine Pilot claim has become. The reason for that is that we don't want employees being put in the position of having to be the hand of the employer conducting crimes on the employer's behalf. This makes a lot of sense. It's completely common sense why we would want this kind of claim to be in place. Otherwise, employers could force their employees to commit crimes and then blame the employee as the criminal and say, hey, look, we had nothing to do with this. That's bad for the employee. It's bad for the public at large. So the Texas Supreme Court said, yeah, let's create a separate what's called a common law claim for wrongful termination, and that has become known as a Sabine Pilot claim after this initial case. This kind of claim is incredibly narrow. The Texas Supreme Court has said that if the employer had any other reason to fire the employee at that time, the employee is out of luck. So, say the employer had written up the employee several times, and it's at that like last, one more strike, you're out kind of situation, and the employer says, we're gonna, you're fired, unless you go rob a bank. And you say, I'm not going to rob a bank, and the employer says, okay, you're fired. If you bring the Sabine pilot claim and the employer says, well, look, we had written them up 3 times and told him he did one other bad thing, that he was going to be fired. He did this one other bad thing, so even if we had not asked him to rob the bank, we were still going to fire him. This other thing really didn't matter. In that situation, as far-fetched as it would be, the employer probably has a successful defense against the Sabine pilot claim. It would be up to the employee to show that any other reason that the employer says they would have fired the employee anyway is untrue and is just pretext trying to cover up the fact that the employee was fired for not being a criminal. There is one exception that broadens the rule, and that is that if an employer comes to an employee and gives them an order, if the employee considers the employer's request and contacts a law enforcement agency to determine whether what they've been asked to do is legal or not, if the employer finds out and fires the employee for communicating with the law enforcement agency, the employee can successfully bring a Sabine pilot claim, although the employer never posed the question or the order to commit criminal act or be fired. And this is also sort of a common sense reason. You want employees to be able to determine whether they're being asked to perform or commit crimes before they commit the crime, and we want employees to feel comfortable doing that and avoid a crime from occurring if whatever the order is might be a crime. And in that sense, it also protects the public at large from an employer who might be asking an employee to commit criminal acts, or maybe trying to cover up the fact that they're asking their employees to go commit criminal acts. So it's really part and parcel of the same underlying reason for Sabine pilot claims, and that's to protect the public at large from employers using their employees to commit crimes on the employer's behalf. Outside of that, so far, the Supreme Court of Texas has said these are the boundaries to the claims. Any other kind of situation, you're out of luck. Go find a statutory claim to bring. But if you do have a successful Sabine pilot claim, the kind of recoveries available are a little different from most employment law claims. Here, the courts will allow recovery of lost wages and benefits caused by the termination, and the employee can recover punitive damages, which not all employment claims allow. And unlike most other employment claims, the employee is not entitled to recover attorney's fees, which presents a problem because if the employee is out of a job and doesn't have a lot of money, they may have to go find an attorney who's going to take a deep percentage on contingency to take the case, or ask for some money up front that the employee doesn't have, and that could leave the employee without a decent option to proceed on these claims. But at any rate, that's what the courts have said. That's where we are with it now. That doesn't mean, of course, that employees or terminated employees should not bring these claims, because the punitive aspect may make it financially viable to proceed on various types of fee agreements on a Sabine pilot claim. The most important thing to consider is that every claim has its own set of facts, its own possible recovery, and so from that aspect, the best thing you can do if you believe you were fired because you refused to commit a criminal act for your employer, or because you sought guidance from a law enforcement agency and you were fired, is to contact an employment attorney and let that attorney assess your situation and determine whether or not it's financially a viable claim for you. But that's pretty much it for today's video. I hope this was helpful. If you've got other questions or you're trying to understand more about the Sabine pilot claims, there's more information on my website, and links to that will be below in the description for this video. Thanks for listening, and I'll see you next video.